Let's quickly turn our attention to one of the big court cases from today. It's disgraced Dr. Nandipha Magudumana going to find out if she's going to be granted bail. Some are saying escaping custody in this case. The Bloemfontein Magistrate's Court will make a ruling on her bail application.
Now, she has been in prison for 5 months since her arrest in Tanzania, and the court heard her claims that she was forced to leave the country. But I must say, Gareth, that moment when she and Thabo Bester were together looking at each other, dove-eyed, starry-eyed, the optics.
Yeah.
And I guess situations like that, when you see that, it basically just nullifies so much of her allegations about having been forcibly taken out of the country. But we do have our senior reporter, Silindelo Masikane, who's watching that, and she joins us now.
Morning, Slee. So let's just talk about the likelihood, if we will, of Nandipha Magudumana walking out of court today. If she's given bail, I imagine it's simply that she walks out of the courtroom. What's the expectation? Morning.
Good morning. Yes, that is what we are expecting in terms of the bail judgment following her application after 4 months in custody. She, as well as Thabo Bester, were arrested and deported in Arusha, Tanzania back in April. And this is after a manhunt was launched for the pair following the news and the articles published by Ground Up, which revealed that Thabo Bester didn't die in his cell in May of 2022. But rather escaped in an elaborate fashion. And of course, we know that there are 12 people who have been implicated in that escape saga. That includes Thabo Bester himself, as well as a Zimbabwean national, and Magudumana's father, as well as former and suspended G4S employees. Now, 9 of the 12 accused have been released on 10,000 rand bail. And for the past 4 months, there have been questions raised around why it is that Magudumana on each court appearance had chosen to reserve her right to apply for bail. And in fact, what we saw was her actually taking her fight for freedom to the higher courts, where she went and launched an urgent application to have her arrest and deportation declared unlawful and set aside. But the 2 occasions in which that was heard in the Free State High Court, that application was dismissed with costs. But there was a judgment around the fact that her deportation was a disguised extradition. So she's taken that particular finding to actually now and try and petition the Supreme Court of Appeal. But in the meantime, she of course then launched a bail application just after releasing a statement where she had indicated that it seemed something was coming, and that was that bail application that was heard over 2 sittings. And of course, the state's then opposing this bail application, saying that she's a flight risk and that her claims of being kidnapped by Thabo Bester are simply just that. It's nonsense, and that she is just trying to weasel her way out of remaining in custody. She is facing a Schedule 5 bail application, meaning the onus was on her to show the court why the interests of justice permit her release. And then she submitted an affidavit to the court where we had an indication of what her defense will be come trial stage, where she says that she did not leave the country willingly, and that she's a mother, and that she's a doctor, she's a first-time offender, really just detailing her personal circumstances around why she should be released, and saying to the courts that she never left the country of her own volition, that she was forced. And so this issue of her being a flight risk really will be further ventilated, or she'll go into more detail during trial stage, saying that at this point she just wants to tell the courts that she didn't leave the country willingly, but will elaborate more on that during the trial.
And Slee, let's just very quickly hear from one of our regular experts that you've had a chance to speak to throughout this entire case, Alton Hart. Just tell us what he had to say when it comes to bail or no bail.
So what we know, of course, is that there is an expectation because of how shocking this escape saga has been and the details surrounding it, and, you know, the amount of people that it required to actually pull this off. There is a sense that, you know, if she gets bail, then perhaps it speaks to the merits of the state's case, that it may be weak. But what our resident legal expert has been saying is that bail is not a punitive measure. It's not something that is used by the legal system to punish somebody. You just have to meet a certain number of requirements, and in essence, you just have to be someone who won't interfere with witnesses, who's going to have an address, you know, that, you know, the law enforcement officials can have on record, and you have to be somebody who will not try and evade justice. The question is Nandipha Magudumana that candidate, given the fact that she had to be fetched from Arusha, Tanzania? Let's take a listen.
In the bail application, she should have most probably ventured into that, to put something there for the court to work with, to say, listen, yeah, I did not, because the state put it straight to say, listen, you used illegal means to get out of the country, so you can do it again. So that weighs heavy on the judge, on the magistrate's mind, when considering to say, listen, yeah, this is a person who's well connected with means, and maybe some finances still somewhere, hiding somewhere, that she can actually quickly skip the country, because she showed us she's done it in the past. The state also said she went out of the country 23 times. Although they did not bring documentation, but it's on the record. It's somewhere sitting there at the back of the magistrate's mind. And I don't think a magistrate can just cut themselves off to say, I'm not going to think about that. And that's all the things that one needs to actually look at and actually, but for me, looking at how she presented her case for bail, she has said something, but I don't think she has said enough. So I feel like she won't get bail. She might take it on appeal to the High Court, and maybe they will grant her bail.
All right, so now, of course, the question of higher courts coming into play as well, and her applications regarding that. So how does this now affect really what will be the start of the trial? Remember, the trial hasn't even started yet, Slee.
So from what we understand, any of the processes that Magudumana launches in the higher courts will be a separate process. They won't affect the trial or the beginning of the trial. And so for the meantime, right now, we're looking towards hearing from the magistrate and the reasons why she may or may not grant Magudumana bail. But I think what we do know, Gareth, is that either way, we will possibly see appeal applications, whether she's granted bail or whether she's denied bail. I think we'll see the state as well as the defense taking this up in the higher courts. So let's just take a listen then to what Mpumelelo Zigalala did say with regards to the higher processes in the other applications rather in the higher courts, as well as what we're expecting in the bail judgment today.
I don't think it would have an impact on any. Remember that when you're doing your bail application, you're not really concerned about the merits. Remember, there's no evidence that has been led, so there are no witnesses that have came into the witness box and testified as to how guilty she is or how innocent she is. So the only test which was being done by the court was the proceedings of saying, is it in the interest of justice to be released? Let's look at what Section 60 of the Criminal Procedure Act is saying and check whether you are a perfect candidate to be released on bail. The trial stage is yet to come. That's when it's going to matter as to what the evidence is. That's when it's going to matter as what the witnesses are. That's when it's going to matter as the sequence of events and the manner in which you are presenting that evidence. And also the defense that you are coming with, to saying, is it a probable defense? Is it something that we can be able to believe in? Is it something in which you are then going to say it was completely something beyond your control? As we've had snippets of her defense during this bail application to say, does it suffice to say I was coerced or I was forced? And yet a few months down the line, you do not act as if you're a person who has been coerced. So at what point did that element of being coerced end? And why didn't you take the necessary step of applying for bail even when you landed in South Africa? Why it takes so long?